Hey, everybody. Thanks to all of you for being here. I'm Jameel Jaffer. I'm the director of the Knight Institute. We're excited to be hosting this event tonight with the Journalism School and at the Journalism School. So thanks to Dean Cogg for making that possible. It's a worthwhile thought experiment to consider what public debate about war and foreign policy and national security would have looked like over the past 20 years if it hadn't been for government insiders who shared secrets with the press. Remember that we learned about the Abu Ghraib abuses only because a soldier who was defying orders from his superiors supplied photographs to the New Yorker and 60 Minutes. When we learned about the CIA's network of black sites overseas, it was because intelligence officials who were uneasy about the CIA's activities revealed their apprehensions to the Washington Post. And 10 years later, it was Edward Snowden, a government contractor, who exposed the National Security Agency's programs of mass surveillance. All of these government insiders, whistleblowers, violated the law. More specifically, they violated the Espionage Act, a law that shaped our public debate about war and foreign policy and national security for more than a century. The newspapers that published those secrets violated the Espionage Act too. When you think about it, it's astounding how dependent our democracy is on the willingness of ordinary citizens, government insiders, journalists, editors, publishers, to risk prosecution and imprisonment. And especially astounding because, as I'm sure our panel will discuss tonight, the risk of prosecution and imprisonment is not at all theoretical. Questions at the intersection of security, press freedom, and democracy are, of course, especially urgent right now, given the role the U.S. is playing in conflicts abroad and the implications of those conflicts here at home. We're very lucky to have with us some of the people who've thought most deeply about these questions. I'm going to let Katy Glenn-Bass, our research director, introduce them, but I want to thank all of them, Margaret, Jeremy, Mary Rose, Sam, for joining us this evening. Thanks again to all of you for coming, and with that, I'll turn this over to Katy.
Thank you, Jameel. Hi, everyone. Welcome. Thank you so much for joining us for this. We have a really fantastic panel. Allow me to introduce them. Immediately to my left is Sam Lebovic, who is a historian and professor at George Mason University, where his teaching focuses on how democratic life and the public sphere have been shaped by imperialism and capitalism in the 20th century. We are very lucky to have him at the Knight Institute this year as a visiting scholar. He's working on a project on managing government employee speech in a democracy. And his book, State of Silence, The Espionage Act and the Rise of America's Secrecy Regime, was published last month. We will be talking about that shortly. Moving down the row, Mary Rose Papandrea is the Samuel Ashe Distinguished Professor of Constitutional Law at UNC School of Law. She's an expert on constitutional and media law and has authored numerous book chapters and articles on topics including government secrecy and the press, public employee speech rights, and government speech. Jeremy Scahill is senior correspondent and editor-at-large at The Intercept, where he is one of 3 founding editors. He's an investigative reporter, war correspondent, and the author of several books. His work has sparked several congressional investigations and was twice awarded the George Polk Award for his reporting. And finally, Margaret Sullivan is a weekly columnist for The Guardian US, where she writes on media, politics, and culture. She was previously a columnist at The Washington Post and with The New York Times as a fabulous public editor, a position I really wish they still had. We are very lucky at Columbia to have her returning to the journalism school as executive director of the Craig Newmark Center for Journalism Ethics and Security at the start of the new year. We're very happy to have you back. Thank you. Tonight we're looking at the Espionage Act in both historical and current context. For anyone who works on or cares about national security issues, national security journalism, overclassification, or whistleblowers, the Espionage Act is probably familiar territory. It sits in the center of a web of problems with the whole secrecy system. But several recent developments make the time ripe for a fresh look at it. First of all, there are several high-profile ongoing prosecution efforts using Espionage Act charges. The long-standing efforts to extradite Julian Assange over WikiLeaks are possibly reaching a conclusion, as he has few remaining avenues for appeal against extradition from the United Kingdom. As you may have heard, former President Trump is being prosecuted for many things, one of which involves Espionage Act charges over documents held at Mar-a-Lago. And finally, Sam has just published Date of Silence, which is a really terrific history of the Espionage Act and the U.S. secrecy regime that offers a fuller picture of how we got into this mess. I'm going to ask Sam in a moment to start us off with an overview and introduction to his book. I will say that while unfortunately we were unable to arrange for sales of the book here tonight, we are going to have a QR code up on the screen, and through the wonders of the internet, you can order your own copy before he's even finished introducing it. I would strongly encourage you all to do so. It's really worth your time. Sam, congratulations on the book. Can you start us off by introducing us to the book and tell us what you hope the new history of the Act will contribute to our current debate over the secrecy regime?
Sure. So thanks all for coming. It's an honor to be on a panel like this. The Espionage Act, if you're a historian, we sort of knew of the Espionage Act really as just like a set-piece thing you would do in your classes on World War I, when the Espionage Act is used to prosecute about 1,000 socialists for criticizing the war, and they go to jail. Eugene Debs is the most famous of these. And then there's a kind of backlash in the courts, which helps produce the modern First Amendment. The Oliver Wendell Holmes decisions in 1919 come out of Espionage Act cases. And so that's sort of the main thing historians know about the Espionage Act. The other thing that most people know about the Espionage Act is it's been used to prosecute whistleblowers and leakers during the War on Terror, as Jameel nicely introduced. And so the idea of the book in the first instance was really to explain how this one law got from being a law that was used to put people in jail for criticism of the war, to censor speech, and how 100 years later it became a law that was used to kind of put leakers and whistleblowers in jail. And that to sort of, through that story, tell a story about the way that the national security state has changed the way it regulates debate in the American public sphere, where once it used to really censor speech, it started increasingly to censor information. And I think that's a kind of important and profound change that the book tries to chart. In doing that, I realized that it was kind of weird that I had never really grappled with the fact that the law was called the Espionage Act and that spying might have something to do with the story. So the book also tries to sort of triangulate the history of spying and spy scares into that story and an evolution of censorship. And I think the story that evolves is important to how we think about the contemporary politics of secrecy in the Espionage Act, because there's a tendency that's pretty widespread to assume that the problem of secrecy is one of those intractable problems in a democracy, that you sort of want to keep some things secret, but then you also need a public sphere full of robust debate, and that balancing these two priorities is always going to be tricky. And particularly American legal scholars and American political commentators are very good at creating after-the-fact rationalizations for what already exists and saying, well, luckily we've muddled our way to a kind of happy middle ground, and the system kind of just works as it exists. And when you put the history together and look at how we got to the present, you realize it was a much more chaotic, random, kind of ramshackle process, that the system was never really designed to work very well, and that the pathologies of the present you can see much more clearly as a result of kind of people making it up over the course of the past century. So what I might do just very briefly is give you a couple of beats of that story, some of the key things that happened to sort of lay the groundwork, and then we can open up for conversation. So the Espionage Act is passed in 1917. In the context of a World War I panic about German spies in particular, although also a panic about Indian anti-imperial activists, sort of nationalists on the West Coast who were trying to run guns back to India to fight the British Empire. But there's a sort of World War I fear. But the key clauses of the Act, the ones we care about today, Section 794, which banned giving information to a foreign government, what we might think of as classic spying, and Section 793, which is a set of regulations governing how classified information or national security information is handled. Those two sections of the law actually come from an earlier statute, the 1911 Defense Secrets Act, which was passed without any congressional debate whatsoever, without any real attention paid to it, in the middle of a panic about Japanese spies on the West Coast, a kind of 1911 racial fear that these Japanese immigrants on the West Coast were acting as nefarious sort of agents for a foreign power and were going to threaten US control of colonies in Hawaii and the Philippines in particular. And those laws get transferred into the Espionage Act in 1917 without much debate, and they all have one basic problem, which is the laws say that it is illegal to do a sequence of things with information relating to the national defense. So you can't give information relating to national defense to those not entitled to receive it, not authorized to receive it. But the Espionage Act doesn't actually say anything, or doesn't define at all what information relating to the national defense is, or what a process would be for who is authorized to receive it. And the reason for that is that the original versions of the law were going to give that power to Woodrow Wilson, the president, but the Congress didn't want to give the president that much control over the kind of information that would circulate in American public life. And so they cut those sections out of the law and never replaced them. And so in 1917, this law says you can't give information relating to the national defense to people not authorized to receive it, and then doesn't define any of the terms, which creates a massive hole in the center of the law, which leads to decades of improvisation as courts, bureaucrats, lawyers try to make sense of how to apply these confusing laws. And the book traces a series of sort of patches and improvisations that come about to make sense of this clunky law that was passed in 1917. The most important of them is actually the creation of the modern classification system, which is done by Harry Truman by executive order in 1951. And so the classification order is the system which defines different classes of information, the same ones that we have today, top secret, secret, and confidential, and the process by which bureaucrats can put a stamp on them as these are the kinds of information that can't get out to the public without risking some harm to national security. And what that law, that classification order, is really a plug into the Espionage Act, an effort to sort of make sense of what those old orphaned clauses were in the 1917 law. And I think the really interesting thing when we think about it historically is that Wilson's Congress in 1917 didn't want to give the president the power to unilaterally decide what information was secret and who would have access to it. And in 1951, Harry Truman took those exact same powers by unilateral executive order, and there was barely a peep of protest. Right? We still live with that same classification system today. It's been tinkered with over the years, but it's never been fundamentally reformed. And that's the origins of today's massive secrecy regime. 50 to 90 million documents classified a year. 4.5 million Americans need a security clearance to do their work. In 2018, the last year for which we had this number, it cost the US something like $18 billion to keep its secrets secure. So it's kind of a massive edifice that's all come out of this patched together system between an old law with big holes and a kind of bureaucratic process established by the executive branch in the middle of the Red Scare and the kind of anti-communist paranoia about spies in the early 1950s. Now, that secrecy regime has massive consequences and massive problems, which we can maybe get into today. But even then, it's still going to be another 50 or 60 years before the law is used effectively to prosecute leakers of secret information. There's one prosecution in 1987, but it's as late as 2000. Republicans in Congress are still saying we don't have a good law that allows us to prosecute leakers, and they pass a new, tougher Espionage Act in an effort to make the law more meaningful. And Bill Clinton vetoes it, and then 5 years later, John Ashcroft basically has another look at the Espionage Act, and the Bush administration, in the context of the kind of leaks that Jameel was talking about, decides that actually this old stitched-together system, which had never been really reviewed by the Supreme Court, which had never really been tested all that much, was perfectly fit for prosecuting leakers. And once a sort of administration arrives with sufficient will to begin bringing prosecutions against people who are blowing the whistle on abuses in the security state, it turns out to be incredibly effective. The law is written so broadly, there are no meaningful defenses for people who provided information to the public about abuses within the security state. And so that's kind of the situation we live in today, a century-long process of improvisation that ends up producing a really powerful kind of patched-together statute and executive practice in the War on Terror.
Great, thank you, Sam. I know our other panelists have all spent quite a lot of time thinking about the Espionage Act, worrying about the Espionage Act. I'm wondering for you, what about Sam's book did you find notable? Did it make you rethink anything or reconsider anything? Mary Rose, can I start with you?
Sure. Sam, I really enjoyed your book, and you all should buy it for sure. So I was thinking about the politics behind this whole situation, and sometimes I think on both sides of the aisle they agree. So I think everyone agrees there's overclassification. I think the problems then come in how to resolve this, and I'm wondering how we could get out of this mess. I'm not sure. I'm just not sure what I think you propose. Perhaps we need to restart, rethink how we're going to fix this. And I'm just wondering, you mentioned in your book how it's hard to get the public to care as much. Maybe it takes, we've had some revelations. Jameel mentioned some in his opening remarks, the torture, revelations about torture and, some terrible, awful things that our government does. And sometimes you get the public outraged, and maybe we can rally them around, like, we need to reform the system. But I think the politics, even before we figure out all the nuances on whether there'd be a balancing test or, how we would actually go about fixing them, like what the politics are behind it. And your book also mentions how, we have Trump being prosecuted on the one hand, we had a Biden and Pence investigation as well. It's obviously overbroad, and both parties are now talking out of both sides of their mouth, but I'm not sure what the way out is. So I guess the politics, you made a lot of great observations in your book, and I wonder how we're going to resolve the political sort of impasse. We all know it's bad. I'm not sure we have the political will to resolve it in the way that it needs to be done, and I agree with you in a sort of very holistic way.
Great. Jeremy, anything you want to add?
Well, I echo the comments on the quality of the book, and even though I'm immersed in this and I've had experience with government investigations into sources and prosecutions and imprisonment of alleged sources, I learned a tremendous amount in the book. And even though I knew the story of how Ashcroft as Attorney General and the Bush administration deliberately began to make sure that there would be a system to apply this to journalistic sources, there was something that just became new again, even though I followed it, in real time and the aftermath. And I think it becomes, and on your telling of it, it becomes far more chilling when you actually are reading it in the context of the origin of the law. So I think even for people that follow this or in some ways live this, because it's their work has been subject to that form of criminalization. I think there's really a vital new telling of a story that's known to a lot of journalists. So I give you tremendous credit for that. It's very, very, very powerful.
Margaret, you want to round us out?
So I guess I as I was reading Sam's book, which is excellent and such an important look at this because it draws together the history and kind of the current situation, I was thinking about an interview I did a few years ago with Daniel Ellsberg. And Ellsberg was giving a talk at Georgetown, and I got a chance to catch up with him beforehand. But during his talk, which was about the anniversary of the Pentagon Papers, he said that he thought it was sad and unfortunate that we've had so few revelations at the level of, anywhere near the level of the Pentagon Papers or anywhere near the level of the Snowden revelations. And he mentioned Chelsea Manning in the same breath. And I think there's no question that we would know a lot more. We don't know what we don't know. And we would know a lot more if it weren't for the sort of chilling effect that comes with this law and the very weird way it's been carried out. And then I guess the other thing that I've been thinking about is, we're all very obsessed with Trump right now, but when Obama became president, he promised to have the most transparent administration ever. And that didn't come to pass. In fact, it was Obama's administration that ended up using the Espionage Act several times. 8 times, I think it was. You might have to check me on that. Not only for leakers, but for journalists as well. And so I guess, where I'm coming from as a journalist is that while I don't think everything should be made public, that there should be a public interest lens on what we know. And Sam actually has a great piece. Read his book, but if you want to read something shorter by him, a great piece in Foreign Affairs that talks about that public interest viewpoint, sort of looking at this whole subject through what serves the public. And I think this act, for the most part, runs against that.
Great. Yeah, Margaret, as you noted, it's the Obama administration that really begins to turn this into a tool to pressure both the press and leakers quite aggressively in the years of his administration. Jeremy, I'm wondering how does the Espionage Act factor into your daily work? How do you deal with the sorts of threats that it raises for you and your sources, and how effectively can anyone actually protect themselves in this sort of situation?
I mean, I guess maybe the most effective way to answer that is just to tell a brief story of a specific case that I continue to be involved with, and it's a case of a young man named Daniel Hale, who is currently serving a almost 4-year prison and sentence, and has for large chunks of it been held in a communication management unit, which where he's treated as basically like a high-value terrorist prisoner, and his communications with the outside world at times are extremely limited, and he also went through a typical form of harassment, moving you around. You can't get mail, can't open commissary, but he's been, I think he's been treated very harshly, to say the least, by the justice system. And what Daniel Hale was accused of doing by the United States government was, of course, they don't name me, they don't name the Intercept, but he was accused of being the source for the most extensive leak in history on the U.S. assassination programs, on the drone strike programs. And but in addition to those documents, he was also accused of leaking to me some 180-page rule book for placing individuals, including American citizens, on the terror watch list. And that practice of watch listing people had become the subject of litigation. Many of the plaintiffs in those cases were Arab Americans or Americans who were Muslim, and they were having trouble in court cases, in part because there was very little information about the standards the government used to place people on the watch list. And if you read the exhibits in that suit, the documents that they accused Daniel Hale of taking and giving to us are documents that we published. We published the entire watch listing guidance. This was when Obama was president. This was in 2014. And it had an immediate impact on litigation across the country, because now lawyers were able to read the standards. And it's an outrageous document. That just completely obliterates basic rights that Americans have, or anyone has, to see evidence against them, particularly when they haven't been charged with a crime, let alone told that they're the subject of any criminal investigation. It was an extraordinary document to read it. It remains chilling. It still remains the most extensive understanding we have of the watch list. Another one of the documents that Daniel Hale was alleged to have leaked was a secret document pertaining to kinetic operations in Afghanistan, targeted killing operations, and statistics from a rather lengthy period of mostly U.S. drone strikes, although there were some conventional airstrikes and some night raids, but most of it was drone strikes, that as many as 9 out of 10 of the individuals killed in these targeted killing operations were not the intended target. Now, that doesn't mean that they were all civilians. It means that that we don't know who they were, and when you then go and drill into the details of that, you also realize, and I think this was one of the most significant revelations from this series that we called the Drone Papers, was that the Obama administration was publicly stating that it was waging a smarter form of war than George W. Bush's administration, because Obama, with the exception of certain surges in Afghanistan and elsewhere, was making the argument that he wasn't putting American boots on the ground. And instead, he was using this hyper-surgical, far more accurate mechanism of drone strikes. And what these documents revealed is that when the Pentagon does not know the identity of the individuals that it kills in a so-called targeted killing operation, the policy is to preemptively label them as EKIA, enemies killed in action, and only if they are a child that they have evidence in a video camera prior to the strike that was present there. If it's even a teenager or a quote-unquote military-age male, anyone killed in those strikes is called enemy killed in action. And so in order to get that designation posthumously removed, a human rights organization or a legal organization, I mean, Jameel, Jaffer, and I worked on a bunch of these cases together when he was at the ACLU, you're trying to prove the identity of people that were killed in an effort to say, hey, you killed civilians here, which is an incredibly important project for any journalist or human rights organization to work on. So all of these documents were alleged to have been leaked by Daniel Hale, and many more of them. People can go and look at them. And his home had been raided during the Obama administration. There's a documentary film that he features in about how his home had been raided for blowing the whistle on drone strikes. He had worked on targeted killing operations for the Joint Special Operations Command and was involved. He knows the number of people he was involved with killing. And so his home is raided, but then nothing happens. And this was, the last years of the Obama administration go by, and it seems as though nothing further is going to happen in the case. Well, then Trump becomes president. And by the way, I had heard also from people at the Justice Department in a fairly informal way, they didn't want to touch it. They didn't want to touch the case. Obama already had so, sort of damaged his reputation in terms of this issue. And I think they were really sort of, I think Obama probably personally was like, I don't want to do any more of these prosecutions. Mm-hmm. So it's simmering still in the background, but I don't think there was any intent to go after this case. Then Trump becomes president. And remember, and now this will bring us back to Sam's and to the current moment. I believe, I can't prove this, but I believe that what we witnessed under Trump when he went so aggressively after the Intercept in particular, and there's a whole legitimate line of criticism against the Intercept in the Reality Winner case. But if you look at what happened is they really went after the Intercept, and they went after, they dug up that case, that Daniel Hale case, and then they prosecute it, and they do it, they start really aggressively going at us. And what happened then is, so I think there's a political dynamic to it. I think that Trump was deeply concerned about the leaks coming out of his administration, and I think they decided to pick whatever cases they could find and throw the book at those people and try to use this to chill other media outlets. And I think it was actually quite successful, to be totally blunt. And I've heard this from other colleagues who do high-stakes national security, document-oriented leak journalism. And there was a chill sent through the journalistic community under Donald Trump. And so that I think is one of the most terrifying aspects of what Sam has written about, how that law was retrofitted to be able to use to criminalize journalistic sources. But it also shows when you have a mad sort of ideologue or someone who puts his petty, he makes his petty grievances national security issues in a total epic fraud, it shows how dangerous it is to have a law like that will be interpreted, that can be interpreted in this manner, even by the constitutional law professor, Mr. Transformative, most transparent administration in history, Barack Obama administration. But we should judge these things on how dangerous are they in the hands of lunatics, because we've elected a lunatic, to be president. We need to talk about that as a matter of serious consequence.
In terms of the threats, talking about the Assange case for a moment now, so this is an even more direct threat to journalism. Margaret, can you talk a bit about how this case is impacting journalism already, and what will happen if he does lose his last remaining avenues for appeal and is extradited to the States?
Yeah, the Assange case is a tricky one because we have to think, and people have to think about whether Assange is a journalist, and journalists have, I think, distanced themselves from Assange because they don't want to be associated with him in many ways. It's debatable whether Assange is a journalist. I think of him more in sort of as a publisher. I mean, he's not a guy with a notebook, but he's he's getting information out there. But I think the key thing is what happens to Assange affects journalism and affects journalists. So for journalists to say, oh, you know, we don't want anything to do with him and we don't associate with Assange and he's over there and we're over here is very dangerous, because when you start to punish what he does in a very severe way, it can easily bleed over into punishing journalists basically for news gathering and publishing. And you know, I'm in favor of, I like to have information out there. That's, you know, my basic sort of, my baseline, but I also think that it shouldn't be done, it should be done with care. And so when Snowden brought his information to The Guardian and to The Washington Post, the editors there carefully looked at, you know, how appropriate was it? How dangerous was it to publish certain things? And then they published a lot of things and didn't publish other things. You know, Assange is sort of in a different category. It's sort of much more of a put it all out there and see what happens. And to some extent, that was true of Chelsea Manning. So, you know, there's a lot of gradations of who's a journalist, who's a publisher, who's a leaker, who's a whistleblower. But I think there's no question that what happens with Assange is going to matter a lot to American journalists, and it could be very damaging.
Sam, do you have a follow-up?
Yeah, I mean, if I can provide, I mean, I think to think about WikiLeaks and the kind of WikiLeaks disclosures in a longer historical context in two ways, I think was helpful to me as I was trying to work out how they fit into the story. So the first is that the law that we've been talking about that's very badly written and vaguely written makes it illegal to communicate information relating to the national defense to those not entitled to receive it. Now, what does communicates mean, right? Does it include just government employees communicating outside of the branch, or does it also include the press, who are obviously going to communicate national defense information anytime they publish it? And I think that vagueness in the law has produced like a century of contestation over the relationship between the Espionage Act and the First Amendment. And the kind of uneasy balancing act that's been reached is that every time that the administration has tried to punish a newspaper for publishing national defense information, which it's tried to do at many different points in time, civil liberties groups and the press have been able to push back and say, you can't touch us because of the First Amendment. We have a right to publish what we can get. And that's been a pretty successful sort of shield at holding the Espionage Act at bay from directly prosecuting journalists for publishing secret information. Civil liberties groups and the press have not been anywhere near, until very recently, as active in trying to protect the rights of the source to provide information to the press in the first place. And the source has become the kind of sacrificial lamb in this settlement, where the government says, well, we have to be able to police secrets within our own domain, and the press says, okay, you can do that as long as we are free to publish at the other side. And that's kind of how the situation has been left. You know, the Assange case, I think, is another example of the administration trying to take the offense one step further again and take on a publisher, right? And so what Assange and WikiLeaks is being accused of doing is receiving national defense information, and so would any other investigative organization that was trying to publish would need to receive that information, would need to hold. It's even a crime to retain that information under the Espionage Act. So there's sort of not easy to see how you can protect the sort of traditional press if you don't also protect Assange. The second piece of context here is that we normally think of WikiLeaks as a kind of radical, slightly scary breakthrough in transparency, that all of a sudden they have this massive capacity to dump huge amounts of information online. And there's some truth to that. But it's important, I think, to realize that whole technological mechanism for receiving massive amounts of anonymous secret information and then being able to publish them without being able to identify the source is itself a reaction to the radicalization of the secrecy regime in the early war on terror, and the fact that there are so many more secrets being kept, and the fact that sources are being prosecuted so effectively. And so if you want to look at a kind of arms race between secrecy and transparency and radicalism, I think it's important to acknowledge that it's the secrecy hawks that kind of radicalize first, and WikiLeaks in many ways is the reaction, not the initial radicalization of the situation.
Great. I want to come back to this question of mass leaks and mass document dumps in just a moment. But first, I wanted to ask Mary Rose about some of the First Amendment interests here, because you've written about this extensively in this context. As Sam said, the First Amendment rights of the press here are generally fairly well discussed. But what First Amendment rights do the leakers have, if any, and what other First Amendment rights should we be thinking about in these scenarios?
Okay, well, first of all, the rights of the press are not well established. That's part of the problem. So as you write about the Pentagon Papers case, such a rousing, at least it has a place of mythology, I think, in our national consciousness. But the decision is the decision of the court is very brief, a per curiam, saying there's a heavy presumption against prior restraint. So the procedural posture, I'm a law professor, so I'm going to use some words like that. So the procedural posture of that case matters. The government was trying to stop publication before it happened. And so the court was able to agree that that stopping the press from publishing, which is called the prior restraint, that there was a heavy burden of unconstitutionality, that the heavy presumption that would be unconstitutional, and the government in that case had not met its burden. But if you then count up, there were many other opinions in the case. The case was decided very quickly, so we have several opinions from the various justices, and if you count them up and you look closely, there are a majority of votes, and of course this is from the early 70s, but it's the precedent, that we have, that you have a majority of the court which leaves open the possibility, very much leaves open the possibility of prosecuting the press after the fact of publication. So Pentagon Papers case does not resolve in the press's favor the idea that the First Amendment protects the press when it publishes national security secrets. And so instead, we have uncertainty because we've actually, maybe surprisingly, we've never actually had a Supreme Court decision that does address that issue. So perhaps the WikiLeaks case would bring this issue to the forefront. If it does go forward, if the prosecution goes forward, these First Amendment issues will be raised. Maybe it would make its way up to the Supreme Court. And it is very dangerous for the reasons Margaret mentions, because we can't really draw, we don't license journalists in this country. We do not have a definition of who's a journalist, who's not a journalist. There are some reporters' privilege statutes that I'm sure you're aware of. Various state legislatures and sometimes the courts and their common law reporters' privilege doctrines have tried to define the press in certain ways, but many of those statutes and the court decisions define what's protected in the gathering of information with the intent of disseminating it to the public. So even those definitions are very broad and would encompass someone like Julian Assange or WikiLeaks. So I'm sorry, you mentioned that it's been well discussed what the rights of the press are, but that is part of the problem. And I think one of the contexts to put the issues of today in are the changes in journalism. And I think that one reason, and I'm not a press lawyer anymore, I know some of you are in the audience. I think there's such anxiety about what's been happening in journalism and the threats to journalism generally, and being concerned that getting lumped together with some non-traditional journalists will tarnish the cause of the more traditional journalists who have been doing such wonderful work for this country, that there's a concern about that. And so there's an attempt to draw the line, but it's hard in the constitutional law to see how that would work out. So I could talk, obviously I've written like hundreds of pages on this, but leakers, so one of the things I love, Sam, about your book is that you do mention how you sort of call out the media for not protecting leakers. And this has been a problem, and I'd love to hear Jeremy and Margaret talk about this as well. And if you see this tension, it is tricky for the news outlets to offer protection to their sources. So that's one dynamic that's problematic, but also the court has just thrown them right under the bus. And we see the court not using its usual vigorous First Amendment analysis when it comes to discussing the rights of leakers. There's this one case, the Shep case, where it's a basically prior restraints on government employees, where the government resolves it without the court resolves it without oral argument, and the analysis is quite unsatisfying, to say the least. So leakers are not recognized, or sources. Daniel Ellsberg said, by the way, at a lecture at the MLRC Media Resource Center, that he doesn't like the word leakers because his wife said it's like reminds him of someone who's incontinent. So anyway, I'll say sources.
I think whistleblower is probably a little bit more positive.
The terminology is an issue, but
Yeah.
the sources. The sources are not protected when they're prosecuted under the Espionage Act. If they try to argue that their information, that what they revealed was not properly classified, that has not been a defense that will go anywhere. They argue they had good motives, or they want to reveal the public. These things are not, they're not working. And so I loved, again, Sam, I love to just draw on your book here. You do mention how there have been recently some helpful signs, maybe some where the press has been starting, and the media law bar and the First Amendment bar has been starting to recognize that we should be thinking about protecting the rights of the sources, that having this dichotomy where we argue vigorously for the rights of the press but then throw the sources under the bus, that this is not really a great situation. And so there have been efforts by the Reporters Committee for the Freedom of the Press to argue that, at least in sentencing perhaps of the sources who are prosecuted, that they should, their interest in revealing wrongdoing to the public should be taken into account. I'm going to stop talking. I'll take more direct questions if you have
That's
any
great.
on this
Thank
topic.
you. I want to give Jeremy and Margaret a chance to respond. I just want to tell everyone, if you have a question for any of the panelists, you can go to this QR code, different QR code, and submit a question through a form, and it will come to me here, and I can work them in at any point during our conversation. Jeremy.
Just on a political level, I think it bears mentioning also sort of the moment that we're in right now on this issue. It's surreal that you have a sitting president who is under investigation for potentially illicitly or improperly retaining classified documents. And, of course, in the right-wing media ecosphere, you have, people believe that it's going to prove that these documents were smoking guns, and that he was letting, Hunter smoke some crack and then go and take them from the, next to his Corvette and read them in his garage. There's a whole narrative about it that sort of makes it into a carnival, but it's a serious issue. And I think I think the press is letting Biden off the hook too easily on this issue, in part because I was recently at a law conference at Yale, and I was mentioning this story that I had dug up when I was working on a piece about Biden. But when Jimmy Carter tried to nominate Ted Sorensen to be CIA director, and Sorensen was a friend of the Kennedy family, Joe Biden colluded with Republicans to tank the nomination of Ted Sorensen. In part, the Republicans viewed Ted Sorensen as like a communist, basically, because of his position on the Korea War, his relationship to the Kennedys. But Biden's gateway into the Sorensen thing was that Sorensen had filed an affidavit in the Ellsberg case. And in the affidavit that Ted Sorensen wrote for Ellsberg's defense, he said that it's common practice for officials in Washington to take classified documents home. In fact, I do it. And he says this now this affidavit was not submitted in the case, but it was filed. Somehow staffers on the committee get a hold of this. And Biden is the senator then who uses it as a basis to say he doesn't support Ted Sorensen's nomination to be CIA director. And he says to Sorensen, I don't know if you should be prosecuted under the Espionage Act or what. So Biden says that. This was when Jimmy Carter was president. And so
It's been around a while, hasn't it?
Yeah, exactly. But the idea that whatever anyone thinks about Julian Assange, he was clearly involved in journalistic activity. And there's a good argument that other people make that it doesn't matter even if he's a journalist or a publisher, just that it is also just about basic liberties, even if it's you want to have a debate, is he a publisher or a journalist or what have you, that there are also fundamental core issues that shouldn't matter if your status is even a journalist, but that's a different discussion. But to have a sitting president, then you have the former president who was keeping documents in his bathroom, who very well may have been using it to blackmail people. I mean, there's some circumstantial evidence to indicate that. Or maybe he was actually using it for espionage purposes of some sort. I mean, that's a total possibility. And so I sort of feel like we have in this moment where we've got old James Clapper, who committed perjury and was never held accountable, on CNN. You have John Brennan, who told systematic lies about the Osama bin Laden raid to intentionally shape a narrative. You have all these official leaks programs that never, ever, nobody does anything. Julian Assange is rotting in a prison where his life is actually in danger. And that's not hyperbole. Like, they're really killing that guy. I think there's actually a moment now, and especially when more than 60 of our colleagues have been killed, overwhelmingly, majority of them by the Israeli military, and the homes of journalists are being knocked to the ground. And their family, today, one Al Jazeera journalist, 20 members of his family were killed, and he had to report the deaths on the air. There is a war against journalism, and this is all related. And I think that given that we have a sitting president under investigation, the former president under investigation, record numbers of our colleagues being killed, this is a time to call the question on that whole structure. Do we believe in protecting journalists or not as a society? And one aspect of it is right in front of you with the current and former president. Let's talk about that law. Let's talk about what that law actually should mean. The Democrats in particular should be taking up this case. But it's a toxic issue for them because documents were found on the garage floor of Joe Biden's Corvette house. So, but we shouldn't shy away from that. And it doesn't matter what any of us think of Julian Assange. That is the case. That is the case that matters, because they're actually torturing the guy to death right now.
Thank you. Margaret, anything to add?
Yeah, so I find myself also thinking about Reality Winner. And, Jeremy said that the Intercept's role in that case wasn't ideal, and they've done great work now, I think, in protecting, in representing her and helping her with her legal case. But leaving that aside, and it's a somewhat fraught and misunderstood situation. It does cast an interesting light on the way that Donald Trump has had expressed such antipathy towards journalists, been very upset during his administration about the leaks, wanted what, can't remember whether it was he or Comey used this expression, a head on a pike. And it turned out, I think, that Reality Winner was the head on the pike, and what did she reveal? It was like one document or something like that. It was very, very limited, and yet she was very harshly punished. So I'm a little worried about the moment we're in and the way things could spin out, particularly if there's a second Trump administration. I agree that these issues could use a lot of reform, and that the law and that the act should be reformed or tossed out or something. I'd be interested to know what Sam thinks about that. But I'm very concerned about the moment and how it could spin out very negatively for whistleblowers and for journalists alike.
So we're going to talk about reform in just a few minutes, but I want to talk about the Trump case first and the Espionage Act charges in particular. Sam, you seem to express a little uneasiness about this in your book, just in terms of the use of the act, or sort of the reaction being so swiftly in favor. Do you want to talk about that a little bit?
Yeah, so I think the general context here is, as Jeremy's begun to suggest, by the letter of the law, the Espionage Act is violated all of the time, right? Any time anyone shares classified information with someone who's not entitled to receive it, so any time a a politician or a bureaucrat sort of shares some information with a journalist off the record, or in theory that should be prosecutable under the Espionage Act. The way that the law is written is so vague that it would be impossible to apply it literally. So what you have to have then is incredible discretion to decide who's going to be actually prosecuted, which means it's incredibly political, and it's always been the case that it's been critics of the administration that are the ones who are being prosecuted under the Espionage Act. It's like a tool of censorship. The book in some ways makes the case that the whistleblowers of today are pretty much the same position as Debs in World War I. They're people saying that these security policies are not in the public interest, and they're hit with Espionage Act charges as payment. And the kind of example I always think of on the other side of this story is Petraeus, right, who famously provided all sorts of classified information, he sort of boasted about it like super high level stuff to his biographer with whom he was having an affair. He gives a public statement about the day that Kyriakou goes to jail, about how terrific it is that we're like upholding secrecy in the national security, and like 3 days later the FBI is investigating him for spilling classified information, and there's no Espionage Act charges. So I think that the law is so broadly written, it's so routinely violated in practice that any prosecutions you bring are going to really struggle to have legitimacy in the public eye. I think anyone who looks at a Espionage Act prosecution is going to say, well, this is just politics, which is exactly what Trump's supporters are saying. That's not to say that you have to draw false equivalencies between the kind of documents that Trump has kept at home and everybody else. I mean, the details of what's in those documents is still unclear, I think. Just the fact that it bears a secret stamp doesn't necessarily tell you a huge amount, given how much overclassification there is. So I'm open to the possibility that there is actual corruption here. I mean, a democracy does need laws on the books to prevent officials from selling secrets for cash. It does need laws on the books to stop espionage. But the current law, because it's so loosely written and has been used for sort of undemocratic political purposes, doesn't have the legitimacy to bring those charges. And then, when you think about it, even in the case of the Trump prosecutions, the real crime is the crime of violating the Presidential Records Act, right, of not transferring the documents over that were supposed to be transferred over, but that has no enforcement mechanism. So this is another case of kind of really ramshackle information handling laws that produce problems, and then the Espionage Act is the kind of useful old tool you can bring out of the shed that kind of gets you out of jail and gives you a tool to bring a prosecution. So, I think the details of what Trump actually did in this case are to be determined. The use of the Espionage Act as the mechanism I struggle with a little bit, because I can't see how it would have political legitimacy, always pending, of course, I don't know yet what I don't know, and that new facts could come to light in the case.
Any other reactions on the Trump case in particular? Okay. Well, I think we're going to spend the bulk of our time now talking about reform, how we get out of this mess, if we can get out of this mess. And again, if you'd like to submit a question for us, please go ahead and use that code, and it comes right here. I've got a few already. But to lead us into that discussion, I was struck by one comment from the conclusion of Sam's book, pointing out that the cynicism about and mistrust of American politics today have been bred in no small part by the cult of secrecy that the Espionage Act helped to construct, which I think goes to what Jeremy was saying earlier as well. So just as a starting point, does everyone agree that reform is needed, or reform would be welcome? I mean, Margaret, I think you might have been getting towards this earlier, but I know a lot of people worry that any effort to open it up would result in something even worse than what we have now.
Yeah, I mean, it's hard to know what would happen, and I don't even know what the mechanism would be for that. I mean, I guess a case that goes to the Supreme Court could, help interpret it. But I think we are so extremely politicized right now, and there's not a lot of good faith anything that it worries me. And I recognize at the same time that reform should happen.
Sam, you lay out a number of possible avenues for reform in your book. Do you want to talk about some of those, and do you have any that you particularly favor?
Sure. So, I mean, there's sort of the big picture idea for reform is just to say that we've got a kind of patched together system of laws and a layering of different laws on top of the sort of old flaws of the Espionage Act, and that, that process basically looks like you've got some criminal prohibitions passed in 1917, then you get the classification system on top of that, and then people get a bit worried about too much secrecy, so you get weak Freedom of Information Act and whistleblower protections, but then there's also another layer of secrecy law, like the Intelligence Identities Protection Act and so forth, and this is a very complicated area of the law. And it seems like after about 100 years, it's probably time to stop and think a little bit better about how the various moving parts all work together and to create some kind of omnibus law that really sort of sets up what are the rules for secrecy, what are the rules for disclosure, and you could sort of think about better how to balance the kind of need for keeping some things secret and also for without allowing for abuse. The two reforms that I'm most taken with that I think would be part of that kind of omnibus bill are some adjustments to the criminal prohibitions of the Espionage Act, which at the moment don't provide you with any meaningful defense if you're acting in the public interest, right? So that's sort of the first that would be, I think, crucially important. And there are sort of models for what that might look like, but that's, I think, at the moment there is no way, Snowden's been criticized for not coming home and facing the music like Ellsberg. And he says, well, if it was 1971 and we didn't know what the state of the law was, I would come home. But as it currently stands, there's no meaningful defense I could make, right? I mean, I'm sort of guilty ahead of the charges, so he remains in exile. So a meaningful public interest defense would be one. And then the second would be classification reform. Since the 1950s, studies have shown that, something like 90% of information that was classified should never have been classified in the first place. And those are studies being done within the Defense Department. So you need a mechanism to prevent the sort of sprawl of massive overclassification and to make sure that things that are only a sort of small class of genuinely secret information is kept secret. The best idea for how to actually effectively do that I have just comes from the first debates around the Truman's classification order in 1951, where the ACLU and Senator William Benton at the time suggested that there should be what they called an anti-censor in the bureaucracy, someone who would audit classification decisions and actually make sure that there is some procedural check within the administration so that if you're at the end of the day, and let's assume good faith, and you're just a little bit worried that you don't want to stamp something at too low a level because you don't want to create some harm to national security, there is another body within the government that will push back and ask you to rethink, or if you routinely overclassify, will make sure that there's some administrative or bureaucratic consequences, and that you try to shrink the size of the classification pool so that you can have more meaningful protection of those secrets which really a democracy really does need to keep, but you don't have the kind of inertial spread of a kind of knee-jerk secrecy regime like we currently do.
Mary Rose, do you have any favored reform options?
Well, I love the public concern defense. That seems definitely well needed. And how it would be applied. And obviously, not all sources would end up getting protected, or even the media, just because it often is considered a balancing test of the need for secrecy versus the public's interest. And it's not always clear how exactly that would end up, particularly in the hands of a judge or the justices, where there is such deference to the executive branch on national security. We've seen this over, decades, where the court does tend to be pretty deferential, but at least, as you mentioned, Sam, there'd be a fighting chance. So that could be very useful. There are other potential structural reforms that have so far been more theoretically possible than actually possible, like inspector generals, for example, like having robust, independent people who are in each of the security departments who could receive concerns and complaints from employees, government employees, who are worried that certain waste, fraud, abuse, illegality, is happening, and provide a way for a neutral body to look into it. And so it's not necessarily going straight to the press, but with being resolved within the department. But we often have vacancies in these positions, and often a lack of them being particularly helpful, which is, I think, what drives a number of the sources to the journalists like Jeremy and Margaret, because they're not getting heard. really Congress needs to solve this problem. Like I said, I don't have a lot of faith in the courts because of their deference to the national security to national security concerns. But like you were saying, Sam, Congress has been incredibly deferential to the executive branch and has not been providing the kind of robust check on the classification authority, for example, that it should be. So again, I don't know how we get the people to demand it. I think it may not always seem politically like not a great political moment for people in Congress to argue that there's too much national security secrecy. I think they often tend to get points from, arguing that they want to protect national security. So it's not always, the incentives may not align in favor of getting the kind of reform we want. But I would think that that's where the main hope would come. It is possible we get something worse than we have now.
It's a for some reason it's a hard argument to make that. I don't understand why, because it's so important to me, but that it's very important to have a conduit for information to get out to the public. There seems to be so much more sympathy for the idea of, well, that's classified and you need to honor that, and my goodness, we don't want secrets getting out. It's really difficult to say, but you wouldn't know about the 5 following huge things that your government was spying on you through electronic surveillance, that there were massive secrets kept during the Vietnam War. And those are the famous ones. But it's just, I don't know really why, but the public who is actually served by this doesn't seem to want to get behind it.
It was as Margaret was talking. I think it actually is a really it's a very relevant issue on whether we would get something worse. And I was just remembering when the Center for Constitutional Rights and the American Civil Liberties Union were leading the battle over confronting the Obama administration's declaring that American citizens needed to be killed and then having them assassinated. They would, of course, wouldn't use the word assassination, but they're litigating this case on behalf of, basically in non-lawyer speak, they were representing the family of a man who the United States was publicly characterizing as a terrorist, but hadn't done much by the way of trying to actually prosecute him in court. And then his 16-year-old son, who was also an American citizen, and that no one ever made any allegations whatsoever with any credibility that he was involved in terrorism. So they're fighting this case, and there was discussion in the circles of people paying attention to this of what happens if we actually bring this to the Supreme Court, and what if we get a bad ruling, and that I think was a really, and I know a lot. I mean, Jameel was one of the lawyers working on this, but the lawyers really, it was very interesting to watch how personally they took it and how heavy they weighed that. And I think the same issue is at play here in some ways, but I think part of it, and maybe it's because I am in the profession of journalism, but I think there was a really epic set of failures on the part of powerful media organizations to report on this war against journalistic sources. The Chelsea Manning trial, Alexa O'Brien, an independent journalist, basically had to shame the New York Times and CNN into really covering the court-martial of Chelsea Manning. And not to keep talking about the Daniel Hale case, but if you go online and you read what little reporting there was done about this case, where they've arrested a guy who is claiming to be a prisoner of conscience and is saying, I mean, what he said at his trial or at his sentencing, Daniel Hale, in July of 2021, he said, "I'm here because I stole something that was never mine to take, precious human life. Forgive me for taking papers instead of human lives." This is a profound statement. That's a statement for the stories of American history of dissidents who stand up. No coverage of that trial, no coverage of that case to speak of. Mm-hmm. Yeah, you can find here and bits and pieces. But if there was coverage of this, especially the issue that you're raising about you cannot say why you did anything in court. Of course Snowden shouldn't come back. I'll debate anybody all night long about that issue with Edward Snowden. Because it's clear there are two ways to look at it. You know, it's a completely unfair trial. And it's against the spirit of dissent in this country, too. So my answer is not about looking to Congress, because I think there is a chance we get something much worse, Margaret. I think you're right about that. But I think journalism organizations can make it a central, unified campaign, because it should defy politics, too, and really report on this stuff. That's why I was alluding to the idea that maybe the Trump prosecution is an opportunity to do that, because his supporters, once they catch wind of this thing, that you're not allowed to actually say why you did something, they're going to think that Hunter Biden basically wrote that law and that it's the worst thing in the world and it needs to get. So anyway, there may be some opportunities, but I think journalistic organizations need to make this a higher priority. And when these prosecutions happen, cover them with the level of seriousness and depth that they deserve, because it's ultimately an attack on the process of just criminalizing the process of doing journalism that's not sanctioned by the powerful.
What are your thoughts on a shield law for journalists at the federal level? Many states have these laws. They vary in their scope, but they attempt to protect reporters from efforts to force them to reveal sources, things like that. Would that help? How much would it help? Other thoughts?
Are you reading my mind? There might be a bug in my head. Okay, yes. So one thing I was thinking as you were, this is such an intractable situation, and I'm not sure, although I agree we should reform the current state of the law. One of the things we can do is protect the sources, and one way to protect the sources is to continue to protect the journalists and make sure that they're not forced to not only testify, but also to protect their emails and phones and all of that, because that's been, lately the way that the government tries to get the information. They don't actually have to subpoena the reporter to get on the stand anymore. They can just go to to Google or what have you and get the information that way. So I was thinking, as you were speaking, that there is bipartisan support for. Right now, there is a federal shield law. Constantly, I report every year for a media law organization on the status of the federal shield law. It's like every year I'm like, and there's another law. There's a law pending in Congress, and it has not been passed. I say that every single year. So once again, there is a law pending that has not been passed by both houses, but there tends to be bipartisan support, at least in one house or in the House or the Senate. And, so it might be that we could get that. There are, going.
Wasn't Mike Pence himself,
Yes.
He had also been a radio, I think he considers himself as having been a journalist. And he actually was better than a lot of Democrats at certain moments in time on this specific issue.
Time.
Yeah, it's, yes, but
Yeah.
I'm just trying to be factual. Yeah, at certain moments in time, Mike Pence showed some legitimate and
Absolutely.
good concern over this issue.
Yeah, and I think,
He's had some moments.
yeah, right.
I feel like I need to take a shower after praising Mike Pence of all people. But.
There were concerns that the members of Congress were getting spied upon, and so that may be leading to more concern about surveillance that is done with under gag orders and that sort of thing. So I think that it is important to continue to fight for the reporter's privilege. I will say that we have these Attorney General guidelines. So the U.S. Attorney General's office has these guidelines. They're completely unenforceable, but they've been around for a long time now. Under the Trump administration, they were probably mostly ignored, but not that they were directly going after the journalists as far as subpoenaing them, but they were going after all their records, we found out afterwards. But there is a very deep tradition in our country of protecting journalists, and that there could be a lot of outrage if journalists were attacked. And so it's possible, a little hope perhaps that we could protect the journalists, and one way to do it is through shield laws, and also requiring and making sure that the technology companies can tell the publishers that they have received orders to reveal information, so that the companies can go into court and fight those subpoenas or national security letters or whatever it might be. So defend the journalists. It's not, it's not great, because I think the sources should also get some protection, but we don't have a tradition of protecting the sources. So, maybe we should just run headlong into what we think we can do.
I think that it's really important. I mean, I've been very glad throughout my career, which I spent a lot of it in Buffalo as the top editor of the Buffalo News. I'm very glad that New York State has a shield law. I think there are, I can't call exactly, I can't tell you exactly what the problems are, but I think there are some issues with a federal shield law that that make it less than ideal. And I know that I've read some things about, good people that I tend to agree with being pretty concerned about what exactly it would say. And I would also add that we're in a state right now in which there's so much mistrust and distrust of the press that it's really changed a lot. And it's a whole different world than it was in 1971, certainly. But even from 10 years ago or even 5 years ago, there's a lot of bad feeling and mistrust. And so I don't know whether a federal shield law would have champions in Congress at this point.
We're getting some good audience questions, so I'm going to start working those in. Thank you all for the questions. I'm going to combine two here, I think, for anyone who wants to take them up. One is a question about whether FOIA reform might help us out of this mess. If more information is obtainable for journalists, there might be less need for leaks. And the other is a question of the effectiveness of the Declassification Review Board and whether that is playing any significant role here.
I'll just make one point about FOIA, which is that, again, Obama looks good in hindsight, I guess now, but his administration was absolutely terrible on FOIA and turned away some record number of FOIA requests. So, yes, I think FOIA reform, but I think it also fits into that category of who's going to champion that at a time when the press is so disparaged and so mistrusted.
I mean, I love the idea of FOIA reform. One of the first things that needs to be reformed is just that very first exception to FOIA, which carves out classified information. It's just a big, broad hole in FOIA that I think we could start with. The FOIA is expensive and big and bloated and takes forever. So there are a lot of problems with FOIA, but one of the big problems is that there is essentially this strong protection for national security information. It can be very hard, not impossible. I know, Jameel, you did some great work, particularly at the ACLU on that front, but it can be a real big problem. So I agree FOIA could help. The classification board, declassification board, I have a note here, and I meant to say that before with structural reforms. I think that the declassification board is a great step in the right direction. It's just the sheer amount of classified information is just so overwhelming. So this board cannot keep up, and but it is a promising idea. So perhaps that might actually even be more. I don't know. With FOIA, you often end up having to litigate and so on. So maybe a declassification board would be another helpful thing.
Yeah, I mean, from the historical perspective, FOIA, the first one, is passed in 1966, and then it's revised in 1974, and, that's normally treated as this, great moment of transparency. What an amazing law. Citizens can go to the government and, petition for information. From my point of view, it's kind of amazing that the US thinks it needs a freedom of information law for the first time in these years. It's a sort of weak reaction to how much new secrecy there is. And it's kind of one of the ironies is that the first time that Congress kind of recognizes the legitimacy of the classification system that Truman had set up unilaterally is in FOIA, where FOIA basically just says, actually, well, if the presidency says it's secret, we don't want to ask any follow-up questions. That looks good to us. So, FOIA is this very weak tool of transparency that presumes that the state is going to be very secretive and then gives individual citizens the right to kind of pry individual pieces of information out if they can kind of stick at it for long enough. It's been incredibly important for some, activists to get information out, but a legal scholar, Margaret, has done work on who most of the FOIA users are, and they are by and large corporations FOIAing for personal profit. There's also a large group of kind of government anti-government trolls who are foyering places like the EPA just to gum up the works and stop the EPA being able to do anything else. So rather than rely on FOIA as a kind of reactive mode of transparency, I think it would be better to kind of roll back secrecy at a more fundamental level through positive disclosure laws. And I agree that the job of just like, how do you scale up something like a declassification board is a real one. But I've had the thought that no one ever seems to like very much, that like putting a lot of resources into declassification and like proactive disclosure laws, like that seems like a pretty good jobs program for a digital age. And it would not be the worst place to put serious resources.
This is no grand insight into it, but just given the company that we're in here and that there are probably lawyers and others who work on these issues, maybe people will find it amusing, but just a case I'm working on right now, and the general counsel for the Intercept, David Braylow, is here, and he's a great FOIA lawyer too. We filed some FOIA documents about a national security issue, and we predictably got back, not that many documents, and they were, much of it was redacted, blacked out. But in one batch of the documents that they gave us, they wrote that they had inadvertently over-redacted the document, but that they couldn't figure out how to get the redaction physically off of it. So they said, here's the text of what it said underneath the blacked out lines. And in the response that David drafted back to the government later, and a whole list of things for why we're heading to litigation, he explains to them how to use both Google and Adobe to reverse their improper redaction, but also saying like part of the purpose of this is that we don't take your word for it, that this is what it says. So I actually am sure it was just what it appears. It's Occam's razor. It's probably just it's just some shit that happened that day in the FOIA room. But it could be something nefarious. That's why we need to keep pressing.
So another audience question, how much of the popular attitude shift towards pro-secrecy views was impacted by post-9/11 attitudes towards national security? And how much of this is a longer-running tendency?
Go ahead, Sam.
I think that there's a basic, fear is the basic kind of emotion upon which these regimes have been erected. Dating back to the first passage of the laws, where the fear is really about kind of international terrorists, spies. When you sort of look at the historical versions of these, they look really paranoid, right? The fear was that the Japanese are about to invade the West Coast and like take the Pacific away from us. And the thing that I like to do in class when I'm talking about sort of the history of national security panics with students is just ask them always to try to specify, when someone makes a claim that we need to be protected from X, to try to work out, well, who's securing what, from whom, and for what purpose? And like one of the things that's routinely, is trying to be secured here is some kind of unequal status or hierarchy or a kind of policy that would be broadly unpopular. So I do think that the context of fear after 9/11 was crucial to kind of creating a permission structure for the Bush-Cheney administration to really ramp up secrecy. But, Cheney had been pushing that kind of attitude to government secrecy since the Ford administration, and he's crucial at beating back some of the reforms that come out of the Church Committee and the disclosures out of that kind of first wave of disclosures. So there's a very political project there about kind of controlling public discourse, and I think I would say take advantage of sort of what are genuine fears that American citizens may have about their security. And this is, in this context, I think, while I can completely hear the rest of the panel on the need to sort of make the case for journalism and like protecting journalism, and I think that that's going to be a losing proposition to the public anytime you say that this is about the liberties of the press vis-a-vis security claims. I think the challenge actually has to be to reclaim the language of security from people who argue that secrecy makes us more secure. Because the public is always going to, I think, say, I'm not willing to risk like letting the wolves in at the door to have like liberty in the press, like that's some kind of abstract concept. So the case really has to be that freedom of the press will produce a more genuine security policy that will actually save lives, save money, and keep Americans secure, and that the secrecy regime as it's existed has actually helped perpetuate some of the worst sort of violations of American national security, both at the level of when you try to keep this much information secret, it's hard to stop leaks, and like one of the things that Chelsea Manning shows is it's pretty easy to like exfiltrate huge amounts of information from the government should you want to, and we're lucky that Chelsea Manning did it to inform the public and not to sort of for more nefarious reasons. But the second is think about all of the policy failures that have come out of secrecy since 9/11, including the lead up to the wars in Iraq. Was a function of kind of the manipulation of classified information. I think you can make the case that 9/11 itself was a consequence of overclassification in the intelligence branches, as well as the kind of adventurism enabled by secrecy in Afghanistan. And so if you can make the case that the journalists' right to know this information is not just about kind of liberal democracy in the abstract, but about producing a more legitimately secure American public sphere and a more legitimately secure American public, I think there might be an opportunity there, but it would also involve rethinking national security policy as national security policy, not just as a policy of secrecy.
Margaret?
So I think that the atmosphere after 9/11 is a huge factor, and this discussion makes me think about an infamous, although ultimately Pulitzer Prize-winning story at the New York Times by James Risen and Eric Lichtblau, and David McCraw, who's in the audience, already knows what I'm talking about, great New York Times newsroom lawyer, in which, the story basically revealed government surveillance of American citizens through electronic means, phone records. And the story was held back at the request of the Bush administration in, I guess, 2003-ish, for many, many months. I mean, I think it was 13 months. And I remember talking with Bill Keller, who had been, was basically made that decision. I think he was the top editor at the time. And he said, very, in a very upfront way, that 9/11 had just happened, and that while the Times wasn't in some sort of state of patriotic rapture, it was affected by the, the perceived and real need to be particularly careful. And so that story was sat upon for a very long time until Jim Risen decided to write a book and put it in the book. And basically, then the Times decided to publish it. I mean, I wasn't in the room, but I think that there was a sort of gun to your head aspect to it. But to me, the interesting thing about it in this context is that it really did have something to do with the atmosphere in the country after 9/11, not only on the part of the government, but on the part of the press. We can debate how legitimate that was, but I think it was a huge, huge factor.
And I would just add that, after 9/11, you also have changes in technology, communications happening at that same time. So there's a real, concern about national security, but also a real insecurity about our secrets and keeping them secret, like you were mentioning, that now you can just have a flash drive and suddenly, millions of documents. Like you tell the wonderful story about Ellsberg, copying, ferrying out a briefcase of documents every day from Rand, one briefcase at a time, copying 7,000 pages. Now you don't have to do that. So when you think about why did the leak prosecution start in full force after 9/11, I think it was in part because there was a real insecurity and that you can make examples. If you think about the number of leak prosecutions, they're rather small in the what we would assume. It's thousands of leaks every day are happening, high levels, low levels, and in between. But the goal, I'm assuming, not being in the government, it would be to help make examples of people to help chill other sources, other government employees and contractors from coming forward because of this concern that, like, oh my God, there's so many documents and the risk is so huge to our country.
Okay, great. Well, we are just about out of time, so I think we're going to wrap up here. I will close with one last thing because I think we all struggle to think about what we can do to help or change any of this. So my one suggestion would be during this holiday season, give yourself the gift of quality investigative journalism, pay for good journalism, make a donation to your favorite nonprofit newsroom or take out a subscription to one that you read a lot but don't yet subscribe to. That is something that really matters. Please join me in thanking our panelists, and please join us for a reception.